Tim Mahoney is back tonight to break down an important new Illinois law. Tim, thanks for being here.
My pleasure. Always great to be here. Good to see you again.
You too.
Happy Memorial Day weekend and happy cicadas.
Excited.
We were talking about the cicadas.
Everyone's
Super
pumped.
excited about those. So Illinois passed a new pretrial release act, the Safe-T Act, and also known as the Pretrial Fairness Act. And it was a complete transformation of the bond process.
Okay.
So now in the past, when you were arrested, depending upon what you were arrested for, you went in front of a judge and a judge set bond. Bond was designed to secure your presence at trial. That was the purpose of bond. And the judge would set an amount of money and then you had to post 10% of that money. And the state's attorney had input on that. There would be a hearing typically where they would give information about prior conduct, have you been arrested before, the severity of this particular charge, and then based upon that, the judge would set an amount of money and you had to post 10% of that money in order to be released.
Like a down payment.
Correct, like a down payment. So the idea with this act, which completely reformed that process, so there's no cash bond anymore in the state of Illinois.
Okay.
And we're one of the few states to have done this, and we're at the leading front of this whole idea. So this is a very new concept, and it was a sweeping reform, that we did. So the idea behind it is to not have cash bail, and the purpose behind it was the theory is that people who are poor or minorities were not given the same opportunities who those who had money, because a lot of what would happen would be DUI, your bond was going to be this. Domestic violence, your bond was going to be this. And so those who had money were able to get out and those who didn't have money weren't able to get out. Also with bond, it was very arbitrary. I mean, a judge in this county might do one thing where a judge in this county would do another, or even in the same counties, they would do very different things.
Sure.
So if you had one judge who normally did bond, but on that day that judge was on vacation, so you had another judge, then it could be very capricious. So they wanted to get rid of all of that and they went to this system. So the system now is, once you are arrested, there's a presumption that you're going to be released, kind of the whole innocent until proven guilty. And whether or not you're detained is based upon threat to the community, something they took from the federal process. So there's a certain criterion of felonies that if you're charged with, you're not going to get released. You're going to get detained pending trial. In order for that to happen, the state's attorney has to file a petition asking that you be detained. So number one, you got to be charged with a specific crime that you're allowed to be detained under. Number two, the state's attorney has to ask for you to be detained. Okay. So now we've now created a level playing field. So whether or not you're detained doesn't depend upon what your finances are. It doesn't depend upon your location. It's going to be the same in Winnebago County as it is, down in Springfield. But here's some of the impact that we've had because of this. Number one, we've taken away a lot of judicial discretion. I talked to a lot of state's attorneys and judges about this before I came in and talked to you guys, and judges now don't get the opportunity to decide who's going to be detained and who not as much. Because before this, a state's attorney could ask for you to be held without bond. But even if they didn't do that, a judge could decide, you know what, I think this person's a danger, and I'm going to set their bond at such an amount that they're not going to be able to get out. So that's one of the challenges that you face with this. I mean, if it's a domestic violence charge, but it's a misdemeanor, an appropriate petition is not filed, somebody might get out who, did a PD level domestic violence. And so that's, not a good thing. One of the other impacts that it initially had is any of these hearings could immediately be appealed. Well, the appellate courts got flooded with appeals from every one of them, so they had to rectify that, which they did. When you're the pioneer of a new idea, you're going to get some arrows, right?
Sure.
So that happened, but most of the indications are that the transition was pretty smooth.
Okay.
Now, long-term challenges with this idea. Number one, these issues when you're on the borderline and we've taken away some judicial discretion. Number two, you got to keep track of the people that are released.
Sure.
And number three, there's no more cash going into the coffers. People would put up a lot of bond in order to get out, and that was money that the county could then basically hang on to, because you could do it in terms of fines. And,
Okay.
So that's not happening anymore. So the long-term financial impact of this is going to be interesting.
Yeah, that was the first question I was going to have. So you got there, you answered all my questions.
So they did accomplish the outcome that they were looking for,
Okay.
that they've leveled that playing field.
All right, well, you can reach out to Tim Mahoney. You have all of the options there on your screen. Thanks so much for coming in.
Thank you for having me.
Coming up next, we'll tell you why this is an important day for expectant mothers. We'll be right back.